Hello everyone, welcome back to my YouTube channel again. Today we are going to talk about dismissal and redundancy. Have you ever wondered what is the difference between being dismissed and being made redundant? And what rights do you have in each case? Today I'll break it down in the simplest way possible. Dismissal and redundancy are two of the most common ways employment ends, but they are not same. Understanding the difference helps both employees and employers handle the process fairly and legally. By the end of this video, you will understand what dismissal means, what redundancy means, and the legal procedures behind them. Let's see what dismissal is. Dismissal simply means when an employer ends your contract of employment. There are different types of dismissal. Dismissal can be fair for reasons such as misconduct, poor performance, capabilities, or unfair if an employee does not have a valid reason or fair process in some cases. Dismissal can also be wrongful if it breaches the employee's contractual right, such as not giving the notice. To ensure the dismissal is fair, the employer must have valid reason and must follow a fair process, which is warnings, hearings, and chance to respond, which is appeal hearing. Redundancy. The Employment Rights Act 1996 defines a redundancy situation to be when an employer ceases to carry on the business in which the employee was employed. This is all about the job, not the person. The redundancy is genuine when the employer shut down the business completely. When the employer closes a particular part of business, for example, a team or a department. When an employer shut down at a specific location. When an employer needs less employee in a particular role. Now, let's see the redundancy process. First one, consultation with the staff. The employers must talk to employees about the proposed redundancies before making a decision. If the redundancy is for the smaller numbers, it is expected that employers consult individually with the staff. For 20 or more redundancies, there is a legal duty to carry out collective consultation with employer representative or trade unions. Second one, fair selection criteria. If only some employees are at risk, the employer must choose fairly who will be made redundant. Employers should apply criteria consistently and keep clear records of how decisions were made. Third one, notice periods. Your redundancy notice period depends on your length of continuous employment, with a minimum of 1 week for 1 to 2 years of service, increasingly by 1 week per year up to the maximum of 12 weeks for 12 or more years. Fourth one, redundancy pay. Employees with at least 2 years of continuous service are entitled to statutory redundancy pay. This is calculated based on age, length of service, and weekly pay. Now, let's look at dismissal and redundancy side by side. First, dismissal is about the person. It usually happens because of someone's conduct, performance, or behavior. In contrast, redundancy is about the job. Maybe the role disappears, the workplace closes, or the business needs fewer staff. Next, dismissal can be fair or unfair, depending on the reason and the process followed. But redundancy must always be for the genuine business reason, otherwise, it won't be valid. When it comes to pay, dismissal usually means you only get your notice period unless you have grounds for an unfair dismissal claim. Redundancy, on the other hand, includes notice plus statutory redundancy pay if you have been with your employer for at least 2 years. The process also looks different. In dismissal, the employee should follow steps like warnings, meetings, hearings, and giving appeal rights. With redundancy, the process involves consultation with staff, fair selection, notice, and redundancy pay. Finally, the risks. If a dismissal isn't handled correctly, The employer should face claims for unfair dismissal or wrongful dismissal. In redundancy, the risks are around unfair selection or failing to consult properly. So, in short, dismissal is about the person and redundancy is about the job, but both requires a fair and lawful process. Let me give you some practical tips. If you are an employee, first, always keep record of the meetings and any communication about your dismissal or redundancy. This can be really helpful if there is ever a dispute. Second, know your rights, including your notice period and if you are eligible for redundancy pay. And finally, if something feels unfair, don't hesitate to appeal or seek advice from HR, a union, or an employment advisory service. If you are an employer, the key is to always follow fair procedures. Make sure consultations, selection criteria, and notice period are properly handled. Doing this not only protect your staff but also reduce the risk of the tribunal claims and keep your organization compliant and professional. So, in conclusion, dismissal is about conduct or capability. Redundancy is about the role itself. And in both cases, fair process is key. If you found this video helpful, please like and subscribe for more simpler breakdown of UK employment law. And drop a comment if you would like me to cover grievance procedure or settlement agreement in my next video.